during citizens to be heard and asks a question or makes a complaint. And that discussion is whether to place this on a future agenda. Again, that discussion should be very brief. Mr. Martin thinks this ought to be on the next agenda. Mr. Martin can say, Mayor, I'd like to see this on the next agenda. And the mayor usually will say, of course. And that's the end of that discussion. The mayor can assure the citizen, come back to our next meeting and we will be talking about your issue. We'll have it on the agenda. The closed session of the city council works different. And I'm going to talk about that after I give this example of how complicated the act and interpreting the act can be. Based upon a court decision in February of 2019, the legislature amended the Open Records Act to change the rules about walking quorums. What's a walking quorum? The Open Meeting Act says that it's a violation of the act if a group of council members participate in what's called a walking quorum. A walking quorum violation occurs. And I'm reading now right from the statute now, the new statute. A walking quorum violation occurs when a member of the governing body knowingly engages in at least one communication among a series of communications that each occur outside of a meeting and that concern an issue within the jurisdiction of the governmental body, and in which the members engaging in individual communications constitute fewer than a quorum, but the total number of members engaged in a series of communications does constitute a quorum, and they all knew that they were going to be having a series of communications that did or would involve a quorum. That's almost word for word what the new amendment to the Open Meetings Act says. What that means is Mr. Martin and Mr. Hernandez can talk about an issue, okay, outside of a meeting. But if each of them then talks to another member of the governing body, all four have violated the Open Meetings Act. Because you had that is how a walking quorum works in real time. And there is case law involving the city of San Antonio, where they were chastised, their council was chastised, it goes back 15 or 18 years ago, for violating this rule. It's discussed in the video that I mentioned. But my message is very simple. Try not to discuss city business with any other members of the city council unless you're in this room during a properly noticed and conducted meeting of the city council. So over breakfast this morning, I hope nobody got together in a group of four and started to talk about, what's the city attorney really going to say this morning? It's safe to do it one-on-one. The problem is neither of the one-on-one know what the other might do. And so the safest course of action is to have your discussions among yourselves in this room during the meeting. That's the safest way to avoid this walking quorum situation. And now that I've explained it, you'll watch the video, and I can't guarantee it'll make any more sense to you than I just did.
Mark, can you also touch base on an email, like when Monique sends, an email to everybody?
Yes, okay. Yeah, can do that.
Thank you.
So, what I advise cities is on any email sent to the governing body to put a footnote on it that says something along the lines of, please do not discuss or discuss this email or this subject with any other members of the governing body to avoid a violation of the Open Meetings Act. There was a case filed in a small town about 10 years ago by a fairly aggressive district attorney who filed criminal charges against two council members who exchanged emails with a third council member in a city where 5 was the quorum. They exchanged emails about when to have the next meeting of the council. Not what was going to be talked about, just when to have the next meeting of the council. And one of them circulated that email to a third member of the governing body, and the local authorities felt correctly it was a technical violation of the Open Meetings Act. And although there was no conviction and the case did not end up with anyone getting into big trouble, it illustrates how even with an email, you can have a violation of the Open Meetings Act, if the emails discuss a subject that's on the city agenda, or even as innocuous as when the next meeting will be, it could be a technical violation of the act. So again, try not to have any of those discussions. Remember the rule that you cannot do it if it involves a quorum of the governing body. So in Kirby, quorum is 4. So if 2 members of the council talk to 2 other members of the council about something, that contract with Mr. Smith or anything else outside of a meeting, that is a technical violation of the Open Meetings Act. And please put technical in parentheses because it's just flat out a violation.
So if somebody wants information, like if Councilmember Martin has information he wants to share with council, he wouldn't send that directly to us. He would send it to Monique, and Monique would send it to the governing body.
Right.
That way, he's not sending us any information with the intent that we would reply to him going back and forth.
Right.
And one thing that, let me add, that's key is when I send out emails, do not reply all. That's the key.
Right.
Reply only to me if you have something to say, because once you reply all, even if I started the email, you have now started a walking forum.
Well, that, you not just started it, you completed it.
Yeah. And that's why, that footer also says, that footer that I use also says, do not reply all. Please do not reply all. It's too easy to reply all. I wish that the reply all button was somewhere hidden, so you had to go look for it first.
So is there any way that, still meeting with Open Records Act though, is there any way to put those in the blind copy when it's being sent to all of the names so that it completely alleviates? At our employment, we send plant emails out, it's in the blind copy so nobody can. It just looks like it went to nobody.
Mm. Well, the problem is when you do that, then someone could think, oh, it doesn't matter whether I hit reply or reply all. I'm not an expert on what
I was
happens.
just curious if that was something that violated, if you had to have the names there, even though it is visible to see.
No, you do not have to have the names there, and it could result in a totally innocent and inadvertent communication.
Right.
If that happens, and I do have one quasi-public board where I put that legend on, invariably one of the 5 members of that board will send a reply all. The good news is nobody replies to that email. So if that happens, just don't reply back. Don't do what someone on one of my nonprofit boards sent an email out about reply all. And then he got one guy responded to him. And what did he do? He did reply all to that response. And we just cracked up. And so I think Ms. Vernon's exactly right. If you get a communication from the city, even if it's from Mayor Pierce, if it comes through the city manager, please reply to the city manager with any comments or questions, and she knows how to deal with it properly and without violating the act.
If you get an email from me, it's spam because I'm just telling you. I'm telling you right now, if you get one directly from me, it's spam, don't open it. Because I don't do that.
Okay. So, and this is really the spirit of this discussion. I was going to talk about email in another context in a few minutes, and I will get to that. But I think the 2 or 3 things about open meetings that I think are really important are: don't take action if the agenda doesn't say action. Don't talk about stuff outside of a meeting, and be careful about reply all and about emails in general because they are potential traps, and it's so easy to avoid, and unfortunately so easy to prove, because there are technical people out there. You may think you have triple deleted something. There are people out there who can find it in your hard drive.
Can you also, Monique, touch on potential quorum when you post those?
Yes.
I'm getting to that.
You're gonna cover that.
I'm getting to that. Okay, so we've talked a little bit about all the things you can do in open session and all those motions and stuff. There are provisions in the Open Meetings Act but there are certain sensitive subjects which really should not be discussed in an open meeting.
I think the battery's
Your mic is
down.
not on.
I think the battery's down, sorry.
Can you hear me? Or do you want me to wait?
It's muffled, but I mean, I can hear.
All right.
I just want to make sure it records correctly.
Yes, those are all good batteries. I don't know why. somebody
I just
turned
want to
off
make
the
sure the
lights.
audio is,
They were good.
I just want to make sure the audio is heard.
Not my phone.
I'm freezing it out when it's cold, so I don't ever use me as an example.
But nobody's everywhere in the city right now.
Do you use your iPad?
Joe, wait to see you post with
No, I didn't know pick one up.
You didn't get one?
I didn't want one. And I get,
Oh, you get a paper copy of your packet.
Miss Cox has to work. Then I don't have to, actually.
It's okay, go ahead.
Okay, so executive sessions, closed meetings. The act permits these under specific circumstances. Things like consultation with the attorney. That could be about litigation. It could be to get legal advice about, well, is this contract legal? It's not about business terms. It's not about facts. It's about getting legal advice. Personnel matters can be discussed in executive session with limits. You can talk about a specific employee in executive session, but you usually cannot talk about a class of employees in executive session. Plus, if you're talking about Ms. Vernon in an executive session, Ms. Vernon can say, I want that in open session. And you're required to then have that, whatever that discussion is, it's in open session. A specific employee controls whether the discussion about that person is in an open or closed session. Some real estate related matters can be in executive session, certain economic development matters, and certain security matters. When the governing body or the staff knows in advance there's likely to be an executive session, the agenda item should include a statement like possible executive session pursuant to Texas Government Code Section 551.071, consultation with attorney, or Section 551.074,